memento to Vidwan's side. I request treasurer of the Vinayak Patkar to offer to all to answer. I request our secretary Parth Patkar to offer talk to. With this, I hand over charge again to our convener. He will do wonderful job today among the.
Thank you, Chairman sir. Thank you, Chairman sir. Now, if I could request the chief guest to say a few words, I can give the mic there if you want, sir. And enlighten all our members present online and offline. Oh, sir, please. Can we welcome you with a round of applause?
Honorable President, the Goods and Services Tax Practitioners Association, Vice President, Chairman, Legal,
Law and Representation Committee.
Legal Law and Representation Committee, Mumbai, and all other office bearers of the association, all the respected senior members and participants, all my colleagues, honorable members of the tribunal, Sri Vidwan sir, Sri Thorat Sahib and Sri Kalu Sahib. Thank you for your warm welcome to me. I learned that this association is imparting knowledge in various states by arranging study circles, national law, coaching classes for beginners, residential refresher courses by visiting different states, guidance by seniors to the juniors one-to-one, and representation to the government for simplifying the procedure, etc. This work of association of imparting knowledge is very appreciable. Nowadays, knowledge is the power, and if you are imparting knowledge, you are imparting power to the persons. They could stand in their life with that help, with the help of this power which you are imparting to the association. Today,
Inauguration of study circle.
Today there is inauguration of study circle in this association. I declare that it is inaugurated today. I extend all the best wishes to the association and to the study circle, as well as to all its activities which they are performing since last many years. Thank you. Thank you.
Thank you, sir, for your guiding words and your gratitude for the association. Now, can I request Joint Secretary Parth Patkar for a well-deserved vote of thanks, for giving a well-deserved vote of thanks. Thank you.
Good afternoon, Honorable President of the Tribunal and all the other members. Good afternoon also to all the office bearers and also the members who are present today. Coming to this hearty opportunity to present the vote of thanks to our chief guest, Sri Mane Sahib. It gives me great pleasure to know that Manesh Sahib actually had such a detailed knowledge of all the activities of our association. It fills me with great pride, sir. Thank you for that. I also thank him for inaugurating this study circle meeting, which happens on at least a monthly basis, and it is a very well looked up upon event, and there is massive participation on that, and it gives us great pleasure to have it inaugurated in your hands. Thank you, sir. I request everyone to please give a round of applause.
Thank you all. Now we can proceed for the technical session. Can I request Chairman Sir Dinesh Tambre to
I will escort you, sir.
escort the speaker Vinayak Patkar sir. Can I request Joint Secretary Vinod Maske to introduce the speaker and the topic for today? Thank you.
Thanks, Shubham. I'm getting this opportunity to introduce the today's speaker. When I was the NLR convener in the year 15-16 and second in the year 22-23. The speaker is, you know everybody, Rona Mahite, Sri Vinayak Patkar sir is a fiery and vibrant personality and dynamic leaders. जवळजवळ महाराष्ट्रामध्ये जे प्रत्येक डिस्ट्रिक्ट मध्ये 36 डिस्ट्रिक्ट असोसिएशन अटॅच त्याचे ते डायनामिक लीडर्स आहेत. Out of that, he is a friend, philosopher, guide, and role model for other professions as well as me also. He also fight cases for the cause of justice. They approach him for his help, and he helps the others by physically also as well as financially. In many cases, he is appearing at his own cost. Such a dynamic personality, and his son, Mr. Ishan, also following the same footsteps of this. With this introductions, I welcome Sri Vinayak Patkar sir. Please welcome it loud applause. I request our president, Sri Kushlan sir, to offer a moment for today's speaker. I hand over the proceeding to Mr. Omar.
I think without wasting any more time, can I request Vinayak sir? Sir, the stage is all yours.
आजचे प्रमुख पाहुणे आमचे माने साहेब, इतर माननीय ट्रायब्युनल मेंबर्स आणि आमचे सगळे सिनियर आणि ज्युनियर मेंबर्स. सर, पहिल्यांदा आपल्याला सांगतो एक वेळ अशी होती की आपल्याला माहिती हे पार्टीशन एवढ्यासाठीच घातले तर मॅनेजिंग कमिटीची मीटिंग होती. परंतु एक वेळ अशी होती की ह्या हॉल असा तुडुंब भरायचा, बाहेर आम्ही परत स्पीकर्स लावायचो, तिथे उभे राहून लोक ऐकायचे आणि त्याच्याही वर जाऊन डिपार्टमेंटचे जे तिथे ऑफिसर्स आहेत तिथे जाऊन लोक बसली. इथे होतं 2 वर्षापूर्वी. त्याच्यानंतर आता हे कोविड आला आणि आजचं हे पहिलं स्टडी झालं. त्याच्यामुळे ही अडचण आलेली आहे. हे एवढी लोक पण व्हर्च्युअल काय झालं, लोक अजून लेथार्जिक आहेत. कुठून इथे यायचं. आणि दुसरी गोष्ट अशी झाली, आज सगळं ऑनलाईन, कंप्लायन्स सुद्धा ऑनलाईन आहे. पण तेवढ्यासाठी इथे माझगावला या. परंतु आता जसजशी वाढत जाते लेक्चर्स, तशी लोक इथे येतील. क्षमा करा आम्हाला की आज एवढीच लोक इथे आहेत, व्हर्च्युअल आहेत. व्हर्च्युअली आहे. दुसरी गोष्ट, मध्ये एकदा साहेब आम्हाला बोललेले, मलाच व्यक्तीच्या दोघे होता की माझी पॉवर डिक्रीज होत चालली. तर आपण चुकीचं बोललो. All of us have appeared before you. Myself, CB, and everyone will say your grasping power is excellent. I am not trying to praise you only for the purpose of praising. We have understood, and every entire bar we know your grasping power is excellent. You understand the propositions correctly and fast. And in fact, all the members who have come this time, we have seen them, their understanding, their is very good. We want to for 5 years.
I said the speed.
Speed is, it's all right, no problem. But we want to for 5 years. And bar will do everything, whatever is possible for the bar, to have all of you for 5 years. Let's see now what happens in the future. Now, the topic is, everyone is interested. सबको लग रहा है अभी क्या 10%. But that is the correct thing. This larger judgment United Projects, that they have upheld the law which was brought in the year with effect from 15/4/2017. They have upheld the explanation also, which was introduced in the year 2019, giving retrospective effect. They have overruled the unsure impacts. Now the position is, irrespective of the period of assessment, whether it is 5, 6, 6, 7, 7, 8, 8, 9, every appeal filed after 54 2017, pre-deposit is mandatory. 10% pre-deposit is mandatory. Now, there was one view expressed in the bench itself by one of the tribunal members, that even the orders pertaining to GST period, that applies. No, that is not a correct view. Because this explanation is introduced in VAT, it is not introduced in BST, and BST is already repaid long back. So therefore, there is no question of this explanation or this law which was introduced in VAT applying that. There, the Honorable Tribunal has still the power to fix up the payment. Now, sir, there were different views about it. Somewhere, some persons were of the view that this 10%, and in fact, in United Political Judgment, Honorable Justice Dhanuka has also discussed. They were saying 10% is good, and he also said 10%, that is because he has explained that. He says, when you are paying 10%, 90% is state. Then why are you afraid of this 10%? He has not said it in so many words, but he is saying 90% is state. So then most of the people, they were of the view that it's better, because that saves time. It saves time of the professional, that saves time of the tribunal, because in arguing part payment matters, a lot of time was getting consumed. So that was the view. Of course, what was happening there, people who have so many components or exorbitant views, then they were opposing. Now see, I tell now all this is now this Bombay High Court larger bench has given this statement, upholding the constitutional amendment introduced by Article 101 and Article 99. I will not go deep into that, because I am aware none of you are concerned with that, those constitutional amendment. You don't want to know only effect of that. However, they have upheld that and they have said the state government has still the power. In United Project, they said that even if bad act is repealed, under the constitution amendment, after constitution amendment, state government has still the power to introduce the legislation. That is what the Bombay High Court is saying in this United Project. However, there is a contrary judgment of Telangana High Court. Telangana High Court is saying that the state government has no power after this constitution. Kerala High Court had earlier again upheld it. Now all these matters will be going to Supreme Court now. What will happen in the Supreme Court is the future this one, because judgment is not stayed till today. Bombay High Court itself has not issued the stay. In fact, in one of the matters, the bench has rejected the stay. Stay was made, but they have rejected. Now, whether they will be approaching the Supreme Court or not, none of us know, but judgment is not stayed. If the judgment is not stayed, then all of us will have to pay 10% pre-deposit, whatever it is, and tomorrow, even if the judgment is reversed, it's of no use to any one of us, because almost all assessments are over. Almost up to June 2017, appeals are already been filed. So it's not now beneficial for any one of us. So better to pay that deposits. Now see, one thing I'll tell you. This judgment makes it mandatory pre-deposit. However, if it is arbitrary, if assessment order or appeal order is arbitrary or non-speaking, you can still move the court, but not for pre-deposit. You can't say that 10% is not the pre-deposit item. You can move the court on the basis of arbitrariness. Now, suppose exorbitant people were afraid only for that, because assessing officers many a times, and that is true, sir. Sometimes assessing officers raises exorbitant dues. So if you raise exorbitant from where I pay 10%. So if my liability as per my 704 and other returns, if it is running in lakhs and if crores of rupees dues are raised, then from where I can pay them. So but such orders can be challenged before the High Court on the basis of arbitrariness under Article 226, and there are instances. Large judgment in civil matters, my matters, large judgment is in Blue Star. You have seen that judgment on High Court. Pass the order, and they asked them, and they gave direction that to assess them as per this. So that is still possible. So therefore, you don't have to worry. Sometimes see, I tell you, this 10% is beneficial also in which cases. Now you see, the same Honorable Justice Dhanuka has given this judgment in United Projects. In United Spirits, that is also given in the same month. Now United Spirits has given the favorable judgment despite having Supreme Court judgments earlier. See, in Ashoka Hotel, this is bond to bond sale. Ashoka Hotel, Supreme Court has said that wherever there is a bond to bond sale, that bond is not within the territory of India. Therefore, it is a sale outside the territory. Thereafter, in Nirmal Kumar Parasar, Supreme Court took another view, and they said that no, in the all bonded warehouses are there in the territory of India. So therefore, any sale effected from bonded warehouse is taxable. That is what maybe on some facts. So that was, because I don't want to explain the whole thing, that it will take much time. Now, in United Spirit, the Bombay High Court has departed from that view. If you carefully read that judgment, he has referred to Ashoka Hotel, he has referred to this one, Nirmal Kumar Parasar, and his Radha Sons also. Radha Sons is international. The judgment of the Bombay High Court, he kept them aside and given the relief to them. He has given justification also for that. Now see, take the case of BSNL, take the case of Pune elevators. All these cases, Supreme Court itself is there after reversing. BSNL, it was a Supreme Court judgment. Pune earlier judgment was a Supreme Court judgment, and thereafter the Supreme Court itself reversed it. Now this again United States. Now what happens, in such cases, had that mandatory pre-deposit of 10%, if it was not there, then he had to pay 100%. You are protected in such, at least for some period. Till that final judgment comes, you are protected. So these are the different views. This mandatory pre-deposit, in some respect, it has helped us. In some respects, it is not helping us, but for that, the remedy is available. Approach the High Court directly. Put up. Now, see, I would like to tell my friends, professional friends, see what happens, and you have to be now careful, more careful. When you appear before the assessing authorities, whether you are or all my fellow brothers from, especially from official area, you don't, whatever you submit, you don't give anything in writing. ते असं चाललेलं असतं, तुम्ही जाता बसता पुस्तकं दाखवता कागद देता, अरे बरोबर कवरिंग तर द्या काहीतरी. In such matters, if you don't give in writing, matters at higher level, they are decided on the basis of material, on the basis of evidence. You can't go, what they do, in most of the cases, you don't ask for the acknowledgements, you don't. What acknowledgement? Many times they are not giving any letters of whatever papers are going, submitting. Finally, when they are dismissing or passing ex parte orders, what does they don't write? What they say? Pardon, so and so did, so and so did, so and so did. Some 1 dozen dates they will write there and then say he did not attend and they will pass. There are instances. When we appear before the higher forum, they ask us, your client had attended, but where it is mentioned. Tribunal at least, because they know they have gone through tribunal, at least sometimes many times they consider, because technical members they know. Therefore, many times we get in tribunal, but High Court we don't. High Court, unless and until you are a pure case where you will show them that the documents were given, it was submitted, everything is on record, explanations were given, then they will ensure that the justice is given. But only on the basis of argument and submissions, no one accepts it. Therefore, be careful wherever you are appearing, either in assessment or in first appeal. First appeal at least to do something, but assessment more particularly, be careful and submit the documents. That you do. Thereafter, if there are exorbitant orders, then we will see. Then in High Court at least that will be set aside and it will be set for the reassessment. Reassessment is a fresh assessment, you can say. Now see, after the explaining you this pre-deposit, I will now explain in which cases. I have explained in which cases it will apply. But now, the most important is in which cases this particular judgment or this particular law does not apply. The first case I explained that GST order does not apply. The second case is, this is the most important. See, when this pre-deposit was introduced on 15/4/2017, the government had also introduced one more provision in section 26, where they have said that if there is non-attendance on same day, 15/4/2017, if there is non-attendance, then matters can be remanded. And thousands of matters were remanded. Thousands of matters were remanded. Orders were not served. orders were not served on the appellant, orders were sent to the assessing officer. Assessing officer passed the assessment orders thereafter. I don't want to now comment on that, why it was done and how it was done, but it was any person having a judicious mind, judicial attitude, he will not do that. That was done in that year 2017. Now, what is the important? Some of us, we have challenged that remand order itself. We have challenged one matter is going on in one page. We have challenged the remand order itself. Now, when you challenge the remand order, this pre-dissolved deposit will not apply. Why I tell you? What you are challenging that remand order. You are not disputing anything. If you are disputing any claim or if you are disputing the tax, then only that will apply. If you are challenging thereafter with the assessment order passed by the consequential assessment order, the after remand assessment order passed by the learned authority, then the matter is disputed. Again, there will be dispute of tax, interest, penalty, whatever. But when you are challenging the remand, because assessment order is set aside. When they are remanding the matter, the assessment order is set aside and there is no tax, interest, or penalty payable. Then where is the question of any disputed amount? There is no disputed amount. So kindly mind it well. I am already contesting this point before the honorable tribunal. So in that case, this pre-deposit is not available. Only thing, whatever is your, they have to either set aside that remand order or come from the remand order. It will depend on the facts of each case. This is one case. Second one is many a times they have appeals are first appeal has been rejected for non-attendance. Then you file restoration application. Then when you file restoration application, in many cases that restoration application is also rejected. Now, when you go in appeal before the tribunal against the rejection of restoration application, there also pre-deposit is not because again what you are disputing this the rejection of restoration. Of course, now, however, in that case, tribunal has power to fix up the part payment. It will all depend on. In one of my cases, Larsen and Tobruk matter, same this. But when the Justice Sardesai had passed an excellent order in there, that he has clearly said that in such case, no payment is required. However, tribunal under that number 6BD, tribunal has power to direct this one. In such cases, restoration of this one, to direct the deposit some amount. Otherwise, pre-deposit is not mandatory in this. Now, under section 26(5)(a), tribunal has power to remand the matter. Remand the matter with directions. That we have decided to appeal, follow these directions and pass the order. Now that gentleman has to pass the order according to the directions of this one. What is happening? We have come across some such cases where tribunal has given some directions and that gentleman, that assessing officer on his own also added some and made the fresh assessment. In such cases, move the High Court directly. Because in such cases, if you come in appeal, then again 10%. He has crossed his jurisdiction. He has to act as per the directions of the tribunal. He can't go beyond that. Now, if he is going beyond that, move the High Court directly. Then don't file appeal in such matter. Separate penalty order. The separate penalty order, there is no pre-deposit. Tribunal has power to fix up the part payment. Again, it will depend upon the facts and circumstances of the case. Forfeiture order. Forfeiture order. Now, fourth bench has given an excellent judgment. That they have the retired tribunal member, Mr. Rathod, in the case of glass wall system, he has followed Supreme Court Constitutional Bench in Ajit Mills had as early as in the year 1955, when I was born. That time they have said that forfeiture means what? Right? When you are collecting, suppose you have collected excess tax, it is deposited in the government treasury. अब forfeiture का अर्थ है जप्ती आणणे. पण तुमच्या खिशात टॅक्स पडला आणि जप्ती कसली आणणे? They had explained this law. That law thereafter Bombay High Court has also followed. The Bombay High Court judgment was not produced there, but Ajit Mills was produced, and fourth bench has already is a recent judgment. They already delivered a judgment saying that in such cases no pre-deposit. But tax is already with them. Where is the question of 10%? So that is regarding forfeiture. Now another thing about C form. This is a very big problem. C form either lost, misplaced, lost because they are misplaced, or they are destroyed in fire. Now C forms which are misplaced, that has been argued by Sri Vai before the again fourth page. Fourth page is again before the fourth page, and he has rightly pointed out that furnishing of form means what? I have the duplicate in my hand and I am producing it. Right? Of course, there is a procedure. Supreme Court is saying that duplicate is not permissible, but at the same time, you have rules. Your rules, and we are following those rules for this one, for getting the duplicate form. And till then it is disputed. At least I have that second copy, third copy with me. Tribunal has appreciated that, and they have given judgment in the case of Asian Granite. It is in the year 2019. Now another judgment about C form, which has been delivered by our Honorable President, that is Paramount Minerals. Now in that case, the farms were destroyed by fire. They have rightly said that in waste judgment, 10% pre-deposit is the requirement. I'll explain that. Now see, whether these are C forms, whether these are books or any other thing, if they are destroyed in fire or something natural, it's a natural calamity. When they are destroyed, you have to follow waste judgment. Even in assessment it is. Now, if some forms are, this is happening. I will tell you, in my case, it has happened. When there was a flood in July 2005, that matter is also with this one. It was argued. Unfortunately, thereafter the Rathods have retired, and again there will be a re-hearing. In July 2005, there was a flood, and all those godowns which were there at Bhiwandi, all pharma companies have godowns in Bhiwandi, and there is no place in Mumbai. Mumbai offices, you have to preserve records for 7 years. This government has extended that assessment. I am coming to that in another instance. For 7 years, you can't assess the people in 2-3 years. You keep on going extending for 7 years. Now, if I have office at Nariman Point or Worli, where will I keep those things? Then I have to store it somewhere, and this is how it was done at Bhiwandi. And Bhiwandi, due to the flood, everything was gone. Then even commissioner issued a circular there, realizing this. Then what people do? They got the certificates from the authorities. Other evidence was produced, and now in those cases, what had happened is, prior to the flood was in July. Some forms were produced before that, and some had remained undone. Now the question is, in such circumstances, what the law requires you to do? The law requires you to do the assessment on best judgment. What is best judgment? What is best judgment has already been explained by the Supreme Court, not today, but in the year 1957 in Raghuvir Mandal, Harihar. And they have said it, you consider it, what is happening here. Everyone has forgotten what Supreme Court has been saying for all these years. If there is no identification, bill to bill घेऊन या. तरच आम्ही देणार, नाहीतर देणार नाही. अरे, you see what court has said. If something is destroyed, no, if it is not destroyed, you must pay and keep on contesting and then take report. This is not permissible under the law. Law has Supreme Court's every observation is the law of the land under Article 141. Now follow that. What they are saying, they have said in that Raghuvir Mandal, you consider the entire circumstances and do the assessment. Therefore, even in such cases that is exactly done by this first bench in Paramount Minerals, they said it is best judgment, and when it is best judgment, it is. And that view itself, the correct view, it's a best judgment and 10% dispute. Of course, there are other remedies also available. He to tribunal. I have filed writ petition directly in the Bombay High Court. What has happened, I'll tell you, in Exchange India Limited. What has happened, same thing, they were destroyed in fire. No, I was not sure whether this here it can be done or not, 100%. We wrote to them for duplicate. The gentleman from, the gentleman is from Haryana. He wrote to us that we can't issue you the duplicate. That is because they are not issuing. There the state is saying this is closed, system is closed, and we are unable to issue. And what we did, we filed a writ petition here saying that this now in such circumstances, if I have to go before the tribunal or before the appellate authority, they ask me to pay 100% pre-deposit. So kindly take this. And simultaneously, we filed writ petition in Punjab and Haryana. Punjab and Haryana High Court that this is what is happening. Punjab and Haryana High Court, I have got the papers if somebody, final order has not yet come. Punjab and their lordship immediately summoned the revenue authority. Why you are not? And our plea is, who is suffering in this? If I am not getting duplicate forms, who is the sufferer? I am the sufferer. He is not the sufferer. Therefore, either give him the forms or allow me to apply. Allow me to apply, and because I am the sufferer. Damage is being done to me, I have to pay this one. And I can't keep on fighting with him for years together in civil suits for recovering my offer. Don't realize. And court summoned them, and I tell you, the day they received the notice, they filed affidavit in the court saying that we issue them. This is what happened. But then see, all this procedure, it takes time. Kindly understand, these are natural calamities. It takes time, and for that purpose, if you ask us to make 100% part payment and then take the report, sir, it is unjustified, and you have given a correct judgment in this matter. So this is all I have to say as regards the deposit of 10%. Now we are visualizing the cases. All cases, it all depends on facts of circumstances of each case. We can't visualize every case. Now, if you have any questions about it, you can ask me. I'll answer them. Yes, sir.
My question is
पहले बोलना मांगता था,
honest,
मगर तैयारी करके आता था.
for no preparation required.
बोल sir.
Then if somebody has no money with him,
I'll explain to you. I am handling those cases also. We already filed writ petition in them. Now what is happening here, I tell you, number of companies have gone in NCLT. See, this COVID and all other this one, And company like HDL and all those companies, most of,
We are not worried about companies. We are individuals who are not able to file and not.
but let me first talk about companies. That is because normally when such brands come, HDL और सीलिंग बनाया उसके पास पैसा नहीं, go and see, it has gone in liquidation. There are number of reasons for that. Economic circumstances are worse nowadays, and they don't have this one. But now what you have done in such cases, even individual, the persons who do not have this, there are 5 repetitions there, and we have left it to the court. What to give? If I am in incident and if I am holding the order, tomorrow I am going to be liquidated. From where I can let them take a call. In those cases, according to me, they will set aside the order and they will ask them to reassess. That is the best they can do because of this one. Let's see what happens. Because finally, he is going to, I tell you, all these matters which have gone in executive, the government has last right to recover. That law is such. The government money is also gone, and this 10% is also. But then see, these are exceptions. The law can't be applied to exception. So that is left to the court. Yes, Dinesh.
There are few cases when actual impacts had come, when an actual impacts was pronounced, and thereafter we filed few appeals in the tribunal or maybe at the first appeal without part payment. Now those cases are pending before those authorities. What would be the fate of those cases after this?
This I tell you. This particular issue is a critical issue. The same United States, the same judge who has upheld the 10% free deposit, in United States is saying, see, there were 2 judges. First is Ashok and thereafter Nirmal Kumar Parashar. So what he is saying, that assessment period, when Ashoka Hotel was there, Nirmal Kumar Parashar came later on. First was Ashoka Hotel. His assessment period will be governed by the Supreme Court judgment in Ashoka Hotel. Now, this is the law laid down by the Bombay High Court in this. Now, here what is happening? Anshul impacts has been overruled. Now, whatever you are saying, that is correct. Your appeal must have been accepted on stamp this one, by stamp number and not have they given appeal number? They must not have given appeal number. You will have to argue it out. You will have to argue it on the basis of this one, that Anshul impacts is on the Bombay High Court judgment. So the assessment, when I filed the appeal, that time Anshul impacts was imposed. Now it has been reversed by the last judge. So don't the pre-given, let tribunal listen. Let's see what they will happen. Yes. अरे आमच्या बाहेरचे मित्र का असतील तर विचारा, नंतर मग परत फोन करून बसता येईल. कोणाला काय असेल विचार, काय आले का मेसेज वगैरे?
नाही.
आज जर now see this judgment, United Projects, the argument was after the repeal of the VAT Act, the state government had no power to introduce any legislation. Now if it was upheld, then this amnesty also would have gone. So we have to keep in mind, see, there are pros and cons.
But sir, amnesty is a separate act altogether.
No, separate act, but the powers is under the Constitution, Article 101, read with that 246A. You can't do it arbitrarily.
The United project has gone to Supreme Court.
Now, see, we are inquiring. That is exactly what say, now, Vikram, I had contacted the other time, they are saying they are considering this. Till today, they are not gone. That is the, Larsen and Toubro is not good. Larsen and Toubro is my client. All appeals for the other periods I have filed in tribunal by being taken because in fact, for such people, a company like Larsen and Toubro, it is beneficial for her. They have 17 divisions. For 17 divisions, one consolidated assessment. If we go for assessment, also there is a difficulty to explain the facts of each other division. Then when you go in appeal for part payment, for the mixed together, I have to argue what were the disputes and so this is pay 10% and get rid of it. But some I advise them not to go for this one. But anyway, there are other advisors also. We persuaded them. Again, you have to pay 10 crores. Why? Now they are coming here again. They are not going. That is what till today they have informed me they are not going, challenging, they are filing appeal. Any other questions on
So
this?
cannot the appellate authority or the adjudicating authority under the VAT Act, like, in the cases where there is exorbitant demand on account of ex parte orders, and we can substantiate by way of documents and the acknowledgements that substantial evidence or documents are given in the assessment proceedings, still those are not considered, then they can they not remand the matter back without applying this 10% deposit?
I will give you a way out. What is happening? I thought today I have one matter like this. I'm moving the court, my court in. Now, you are very right that you have submitted the document, and despite that, they have either made ex parte order or they have raised exorbitant. But then, appellate forum, the appellate authorities which are constituted under the impact act, they will not be able to hear you unless there is a pre-deposit after this act.
So just a suggestion, since the honorable members are here.
Do the suggestion.
No, I'll just,
Giving them a suggestion will be of no use.
no, suggestion in the sense of view.
Finance department and joint judiciary.
Yes, absolutely, sir, absolutely. Just a view. See, there are cases which are filed after Anshul Impex was holding the field. And that time, there are some cases which are ex parte orders and exorbitant dues have been raised, and the assessee or the appellant can substantiate that the substantial evidence of the documents or the documents relating to their claims are available on the record. Still, the ex parte orders have been passed. In such cases, a lenient can the authorities at the first appellate level of the tribunal take a lenient view by using those remand by provisions and without fixing any part payment, as the Anshul Impex was holding the field at that time, remand the cases back for adjudication?
You first forget first appellate. First appellate authority will not do anything. There is not a single person in first appeal who can take, because they have their own problems. It's not that even if somebody feels that injustice is because they are afraid about that STR and this one, so therefore no one will take this. Tribunal, if you ask my view, it may be a correct view, may not be a correct view, but I am saying my view is that even tribunal will not be able to take any conclusion, because now law is explained by the larger. In such cases, what is required to be done? You move for rectification. Let them reject the rectification, then you go for High Court direct. That order is required to, that is what I am saying. Either you move for rectification, and if rectification, if is setting aside the order, the matter is different. But if it is now, he is not doing it, then move the court. That is exactly what I am saying. The authority is constituted under the Act will not be able to help you. Now, one more case I'll explain to you. This is the most important case because many of you will be confronted with this. All appeals filed under section 18A of the Central Tax Act 1956. I'm sorry. Now see what is happening. In 19, Ashok Cleland was explained by the Supreme Court years back in 2004. A mechanism was thereafter introduced and appeal has been provided directly to the tribunal from the assessment order itself. Now, what is happening when there are back-to-back sales? The gentleman, the assessing officer in 99% cases, this is happening. I claim the branch transfer. When I claim the branch transfer, naturally, I am under 6A1. I have to have the F form. Now, when they assess them, they don't talk anything about these declarations and this. They are directly applying that law, English Electric Company and this company. That I think this legal department or commissioner's office must have given them 4 or 5 cases. So cases they are reproducing in the order and passing the order. Once that order is passed, the claim of branch transfer remains as it is, and directly appeal comes to the tribunal. Now, kindly listen carefully. Now, when it comes to tribunal, when such order is there, you can't go. You can't go before the first appellate authority. Now, when such cases are coming to the tribunal, in some cases, tribunal has, how many have come? Where is the question of it? You see the order, you have passed under section 18A, you decide about 18. Now, if you are saying it is interest rate sale, even if the assessing officer is saying that it is interest rate sale, where is the question of F form? But that apart. Now, after it has come to the tribunal, even if it is remanded back, I am of the firm opinion that in such cases, no pre-deposit is required. Not even 10%. And I am going to argue this when the issue comes. I'll tell you. You read, there has to be order. There has to be order on that issue and then disputed tax. There is no order. You don't say that the forms have not been produced, or even if you say some forms are produced, you don't determine how much tax is that on. Thereafter you are applying this one. Now what your law says? See section 26. That before 2 years or after 2 years, after 2 years, no stay will be granted under. But after 2 years will run from when? When the tribunal reminds the order. And ask you, thereafter it will run, otherwise it will not run. And before 2 years, there is no question. See, this law is arbitrary. We are already challenged. In Schindler's, we are before the High Court saying that this is arbitrary order. See how the orders are being passed. And let the revenue come and show to the court which are those orders they have passed in 2 years. No assessment was done within 2 years. And you are saying that if it is not produced within 2 years before the assessing authority, then they have to pay 100%. Anyway, the court will take the call. So this is regarding 18A also. Anything else? भाई कल पैसा लेगा कुछ yes brother.
Regarding 18A only, there is a branch transfer. There is a assessment under section 23(5) where the forms are not received and it is disallowed. The dealer applied for rectification, but the forms have not come because the branch at Delhi, they are not issuing the forms because it is a warranty sale. Now the appellant wants to dispute the fact itself that F form itself are not required in such cases.
Correct.
So can directly the appeal be filed?
It will be 10%. I tell you other types of cases. Now, see, this one, your samples, pharma company gift articles, they are being sent to doctors. It is no depot transfer. Unfortunately, before my lord was not there that time. I think that is Justice Devrej's judgment. Unfortunately, in one of the pharma case, their manager appeared before the tribunal and tribunal has taken contrary view. However, there is a Bombay High Court judgment, which when it comes, we will show to the tribunal. That judgment is incorrect, which has been given by the first bench, where they are saying that in such cases also, if Justice Dharmadhikari has given a clear judgment in this regard, saying that that is a Rajat's case. Rajat Talati case. Yes, exhibition comes. Yes, he has clearly said in that. But now it will have to be brought to the notice. This is the unfortunate thing that people, without studying the law, they appear and get such judgment, and then everyone suffers. Your case, 10% pre-deposit only, not beyond 10%, because this is not a case where the form is required. What the law says, that firstly, the transaction should be against the declaration. Now, if the transaction itself is not against the declaration, he may say that it is branch property. It's a dispute. Dispute about the transaction itself. Dispute is not about the yes. अभी आया पहलवान. Yes, sir.
Sir, in case of ex parte order, because we have got a problem in ex parte order, most problem. Now, despite submitting the details, in a lockdown, they have passed the ex parte order. Now, we can file appeal against the ex parte order itself, not on the claims, but on ex parte order. Then is it possible to argue that this 10% is not required?
No. You can argue about 100%. But you can't that declaration, but you can't argue about 10%.
Sir, वो जो कमिश्नर का सर्कुलर है,
कमिश्नर को छोड़ो बाजू में वो
I am telling you that he has said that when you are disputing any claim in the assessment order, if you read this provision, when the appeal is filed against the claim, then 10% payment is required. If it is in case of any other, no part payment required, that is the commissioner circular. The commissioner has given a circular and they have given examples that in case of a cancellation of registration, no part payment is required. Then like that in case of a rejection of an application for rectification. Rejection of an application for rectification, no part payment because I am not filing.
You are not there. It's that time when I explain again rejection of rectification, there is no problem.
So like that.
Problem is, listen. Problem is about what you are saying, Commissioner Circular in ex parte this one. Now I tell you, beto, समझ गया आप जो बोल रहे. See, we have been day in and day out citing Indra Industries that Commissioner Circular is binding. Yes, it is binding, but where it is binding? Where the circular explains the correct position of law. If circular is not this one, there are judgments on this. If I tell you why the judgments are there. That also I tell you. If the circular is contrary to the law, that is not acceptable. And that judgment, if one of the judgment the court has discussed that people are going, they have their own people there in government and taking out the circular. So they have made the observation. Therefore, whatever it is circular. Is according to the law, it is binding. If it is not as per the provisions of law, it is not binding.
Sorry,
And in your case, that ex parte 8%. Otherwise, you move the court. This is what I am doing. Now, one in recent order, I am moving. They have submitted everything. They have the letters. Unfortunately, that is exactly what I am saying. When you people are going in the assessment, you don't take acknowledgement. There is a circular from the commissioner that the department authority should give the acknowledgement. The circular is that despite that officers are not giving, and you are also not giving. But fortunately, in that case, the letters are on record. On that basis, I'm going to the court. That when all these submissions were made, why there was the ex parte order. So this way you can do, but you can't compel the authorities here to accept your appeal without pre-deposit. 10% pre-deposit will
Yeah,
come.
on the interpretation of that provision. That when 10% is required, then if you look at the 2016 language itself.
Now, this is not the forum where we can discuss this provision.
So yes, studies will
We'll see, we'll see, but this is what my view. Again, if you want 3-4 of us, we'll sit and discuss.
You charge 10%.
Huh?
Charge him 10%.
And we'll charge.
The online pay query, there is one query in the online. Every time, I will not read the query. What I have understood, I will tell you. They are asking whether the T-nexus verification is compulsory. If every time, you must be aware about the T-nexus verification. T-nexus is the site which doesn't have any, according to me, there is no authenticity to that site. But the T-nexus verification is done for allowing that C-form. And queries is asking, if they want to verify T-nexus, then why they want original C-form? If my original C-forms are missing and they are available in T-nexus, then why they can't allow the T-nexus verification only without taking declarations on the record?
One thing. After this automation, even if you are getting those online forms, duplicate form thereafter, officers are allowed. Assessing officers are allowing, tribunal is also allowing after this one. Now that procedure, no one is insisting now that to get that duplicate, those that C form, rate lines in income, what rules are there, they're allowed. However, for T-nexus verification, there are no rules in the list. Nothing is mentioned in Bombay rules, nothing is mentioned in the central sales tax rules. But it is in your interest. See, when you raise such queries, you should also understand. And all our official members are also there.
They have raised.
So therefore,
They have
as
raised.
far as possible, give them the verification. If it is not given, see what happens, if you directly tell no, it is not fraud, they will not do it. And if there is a contrary judgment tomorrow, they will suffer.
He is on the contrary asking that if my original declaration is missing, but my form is available on the T-nexus
But they are
website,
allowing.
why? No, without taking, he wants that without taking the original declaration, you allow on the basis of the system, whatever system is showing.
But that is they are, over I know, yes, CB, they are giving no.
No, sir. Sir, they are not allowing, they want original declaration on record.
One or two cases in tribunal, allowed by this one.
It is contrary judgment. Even if it is not reflected on T-nexus, still you have to give the original product. But based on T-nexus,
Then that is because of the Supreme Court judgment, Suyada Manoj. Now in such cases, what one has to do, you approach the court again and tell them, your judgment, whatever judgment you had given earlier, that was of the prior period when the manual declarations were there.
correct.
So now the systems have changed. And I will tell you, if the matter goes before the justice like Justice Chandrachud, he will definitely give it because he is after automation everywhere. But then we will have to approach the court. This tribunal and this first appellate authority will not be able to. But I will tell you, in one or two cases, when I gave them the form downloaded from this one, they allowed it. So I don't know what is that.
So you
Yes,
can
sir.
download it.
One of my cases, this is a thing, they rejected the place not on the basis of TINEX. They said, you can verify it from TINEX, but the form is required because the company had a branch at Tamil Nadu, the company has a branch in Maharashtra. So the forms were given in Tamil Nadu and then he was claiming it here. In TINEX, you can verify it, but you cannot, you are required the original C form only for the fact that it should be produced in Maharashtra also. That was their contention.
Physical form they want on the record.
But
is
in
what.
annexes, you can actually select the state which is issuing. So I don't know how that is a.
That was one of the issues that was raised.
Umang is answering your query. What we can do, Mr. Rao, evening we will meet and discuss. Okay, forum. Yes. Umang will not be joining.
We save our expenses.
This Umang Talati is our Chartered Accountant, CA Rajat Talati.
Sir, but I can take
He is also
10%.
CA.
But I will take 10%. I will not join. But I will take 10%.
Yes, go ahead.
Every forum, the 10% of the balance amount is expected.
That is the correct law. They have provided by way of this one explanation. First appeal,
10%.
while you are filing first appeal, pay 10% against the dues. And thereafter, when you are filing second appeal, again pay 10%
Of
against the
remaining.
remaining dues. So that is the explanation has been provided.
Yes.
As you say,
बड़ा कभी कभी ट्रांसफर मेंबरशिप समझ ला
the same dues, they are controlling the same dues, they are again asking for a 10%. What is the analogy between? Because once they say at one forum, say 10% is okay. Another forum, the same dues, you get 10%, additional 10%.
Now that is the law, you can't now exclude it. Yes, anything else?
You are saying. Nowadays, another people is saying,
नहीं साहब we actually गम्मत करो but sometimes yes sometimes it is like yesterday when you were patiently hearing that matter which the lawyer was again and again referring to refer it to the larger bench.
Sometimes,
but पुष्कळ patience दाखवला गेलेला.
everybody sitting in the hall.
तर पण तरी म्हणजे आपण खूप पेशंटली ऐकून काय झालंय त्यांचं पण वय झालेलं आहे जोशी साहेब आमचे मित्र आहेत ते डी जोशी त्यांच्या तर ते बिल ठेवून but then see it's as a you should not come to the term. I stop the day I realize that I am not going with my either barabar nahi hai I will stop. अरे बाप almost 45 minutes sir
When you will come to Barabar?
अभी वो चल रहा है समझते anything else नहीं तो
राव सर ऑनलाइन उन्मेष नार्वेकर
हाँ बोला
सर एक छोटा सा पॉइंट है that means that these people only will get the law justice because there are many people who are not able to pay 10%, their appeals are not accepted, so how they will get justice? And these appeals are the orders, assessment orders are passed with a high pitched demand having no base at all. So these people, what is the remedy for them? What can be done, sir? Please.
I think the question
Question is what is the remedy in high pitch orders? I think sir has explained this.
we have already मराठीत नंतर सांगतो का
परत एकदा मराठीत नार्वेकर साहेब मराठीत सांगतील ते फोन करा.
या चालेल
त्याच्यामध्ये एवढंच हायकोर्ट ऑर्डरला हायकोर्टला जायला लागणार आणि हायकोर्ट तसं करतं त्याच्यावर जजमेंट पडलं ते क्रॅश करून टाकतात का ऑर्डर
ओके
ओके म्हणतात.
ओके सर थँक्यू
so I conclude and take your view. Thank you very much.
sir, thank you very much.
सर तिथेच बसायचं तुम्हाला.
माझा निर्णय.
मग तिथेच बसा तुम्ही.
Thank you, sir, for such a good exposition. Now, formally for addressing a vote of thanks, I would request Treasurer Mahesh sir for giving a well-deserved vote of thanks.
Before that, I would like to thank all the tribunal members for remaining present for what was happening in past some years. This is why the vote of thanks was given to the chief guest, honorable president, immediately after this one. But they are going away. This is the first study circle meeting. Yes, yes. ते म्हणजे ती सुद्धा जे आम्हाला बरं वाटलं ना ते सर आम्हाला बरं वाटतं की तुम्ही थांबले कारण सगळ्या लाईनी शिकून जायचं एक तेवढं अर्धा तास आम्ही काय म्हणतो.
Thank you very much. President Sunil Krishnanidhi, all of his leaders, members, and past presidents of GSTPAM. I am here to propose ideas of thanks to the speaker as well as the chief guest. Mani sir has actually, Patkar sir has already given really vote of thanks to our chief guest, and he is there present, and he was very much alert for each and every comments given by our Patkar sir. Thank you very much. And Patkar sir, we are really blessed that you are the first speaker in our series, and I'm thankful to all the queries raised by all the online participants, and thanks to all the chairman of this committee, conveners, they have done really excellent thing. Thank you very much.
With this, we'll be concluding our first study circle. Just a small announcement. We have your managing committee meeting, which is going to be happening at 4. So I would request everyone to remain present after this. It will be here only. Thank you.
National anthem.
I would request everyone to please rise for the national anthem. Jana Gana Mana Adinayak Jaya He Bharat Bhagya Vidhata Punjab Sindh Gujarat Maratha Dravida Uttal Ganga Vindhya Himachal Yamuna Ganga Uchchal Jalati Taranga Tava Shubha Name Jage Tava Shubha Ashish Mage Gaye Tava Jaya Gata Jana Gana Mangala Dayak Jaya He Bharat Bhagya Vidhata Jaya He Jaya He Jaya He Jaya 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 He
Mata ki
Jai. I request the online link members to be also present. The Noyer managing committee meeting will also be on the same link. Thank you.
सर असं आहे आमचे सगळे
Yes, sir.
Yeah.